Hello, thanks for joining us. Today we're going to discuss your relationship with an employment lawyer, when to call the lawyer, and how to manage the relationship so that it's efficient and effective for you. So our agenda for today. First, we're going to touch on some of the more common employment law issues and challenges that I see in my HR consulting practice. We're going to do a little bit of employment law triage, drawing some analogies to the medical profession, talk about what's routine, what needs some focused attention, and when to call in a specialist. Speaking of specialists and generalists, why you might need both. How to prepare for phone calls and meetings so that you use your chargeable time wisely. Taking advice, which is not as easy as it seems sometimes. And then we'll have some time for some live Q&A. So there are three general areas in which your business might need or could invest in advice from an employment lawyer. First of all, we can look at pre-employment setup type stuff. This is where you can just as easily use an HR consultant or perhaps your own in-house HR expertise, if you have that individual, to do most of the heavy lifting with consultation with counsel as required. Small and medium-sized business owners and managers often don't have much structure around hiring processes and tend to approach hiring on a somewhat ad hoc basis. It's both efficient and smart risk management practice to follow a consistent practice in hiring matters. You should have a hiring practice that is as bias-free as possible, beginning with job postings. Solicitations for new employees, ads, online postings, etc., need to set out bona fide occupational requirements for positions only and avoid subjective requirements. During interviews, ensure that your questions are consistent and focused on the position requirements. It's easy to allow interviews to take on a conversational tone, which can lead an interviewer down a risky road. If there's particular questions that you're not sure if you can ask, you should seek out that information. There are likely ways to find out what you legitimately need to know about a candidate without being discriminatory in your questioning. As an example, if you feel that you need to ensure that a candidate has no physical impediments to performing the job properly, you can set out specific duties and ask if they can perform those duties. You can't say to someone, do you have a bad back? But you can say, are you able to regularly lift 50 pounds? If you're aware that a candidate has childcare responsibilities and overtime is required on occasion, you could definitely set out the requirements and confirm that the candidate can meet them. But you can't say, who will take care of your children if you're required to work overtime? You should also ensure that any pre-employment testing or investigations are both consistent and reasonable in the context of the job. If a position requires that an employee drive a vehicle, requesting a copy of their driver abstract is reasonable, for example. Having a properly constructed and structured recruiting process can go a really long way to keeping you out of legal trouble and to ensure that you get the best candidates. Putting these kinds of processes in place and checking with an HR professional and perhaps an employment lawyer is a great investment. Once you've found your perfect candidate, you should make sure that your offer letter template includes start date, reporting structure, compensation, basic duties, adherence to policies, confidentiality requirements, and potential termination arrangements. Having your letters reviewed by an employment lawyer periodically is a very good risk management strategy. These letters can be most economically drafted by an HR professional or consultant for a lawyer for review. For your ongoing employees, you need to ensure that expectation setting, performance management are all bias-free and as transparent as is reasonable. It's also crucial that you ensure that you are compliant with all applicable legislation. The Occupational Health and Safety Act, AODA, the Employment Standards Act, the Human Rights Code. Again, a consultant can do much of this work for you, but in particular, you need to be advised on what applies to your business. We're highly regulated in Ontario, and even very small businesses must have policies and conduct training and regular monitoring in these areas. You've undoubtedly heard of some significant changes afoot to the Employment Standards Act, which underscores the requirement for businesses to stay on top of such change and how it specifically impacts on you. Severing employment. This is the area where employers are most likely to pick up the phone to call the lawyer, understandably. Dismissing an employee can have wide-ranging HR, operational, PR, and legal implications. The issues you need to consider when it comes to ending employment can be talked through with an HR professional or consultant to frame the discussion with a lawyer. The kinds of factors that you need to consider are whether the dismissal is for cause or not, and dismissing for cause is a very high bar. It should rarely be contemplated without legal advice. If dismissal is not for cause, then notice must be given, either in working notice or monetary payment, or some combination thereof. The Employment Standards Act sets out minimum requirements and minimum entitlements, but these are rarely sufficient to protect against a wrongful dismissal claim, and a departing employee cannot sign a release based on payment of ESA minimums only. Deciding what to pay to satisfy common law standards insofar as you can needs to consider various factors with respect to the employee. We'll talk about them a little later, but they include age, service with the company, position, salary level, to name a few. You also need to consider the external market, i.e. how easy will it be for that individual to become reemployed. And there are potentially extenuating circumstances. Are there any potential human rights or discrimination issues to be considered? It seems quite evident that this is an area where investing in a relationship with a good employment lawyer will pay dividends. And then there's the dreaded lawyer's letter. A labor colleague of mine many years ago told me that if a business never gets a letter from a lawyer demanding a larger payout for their client, this means that business is paying too much severance. I'm not sure this is entirely consistent with my current values and philosophies, but it does underscore the fact that these are not black and white issues. The decisions that you will need to make in terms of responding to such a letter should be informed by a discussion with a competent employment lawyer. You should consider what your risk tolerance approach is. You will also have to be really careful to manage your emotional reactions to such a letter. You're likely to have them, and we'll talk about that issue in a few minutes. So I'm going to use a couple of medical analogies in the next section. The first one being the concept of triage. So of course we all know what triage is. Triage is when the medical profession decides what treatment is needed for which patient and when, what is more serious. So the fellow with a sprained ankle in the ER room is likely to be seen well later than someone who's experiencing a cardiac arrest. And the second patient will likely need to be seen by a specialist or several specialists. In addition, the regular doctor visit for many of us now has in many cases been replaced by visits with nurse practitioners, who are often able to provide more cost-effective and personalized help. Your internal HR person or professional or HR consultant may be a better choice to assist with policymaking and day-to-day issues. They can be your nurse practitioner. A good consultant will know your business and your people and should be able to make sure that all of your policies and procedures are working well for you and that you're in compliance with all applicable legislation. So how do you know when to go see the doctor, the lawyer, that is, or head to the emergency room? Well, that depends on a number of factors. A very big one is your own level of HR experience or expertise or comfort level and your risk tolerance. But you should definitely get lawyer sign-off on any major contract issues if you intend to make any substantive changes to your employment agreements with your people, and certainly you should contact your lawyer if you are contemplating anything other than a very routine termination. So what's your routine termination? Generally one where the employee has relatively short service, entitlements on termination, and that there are no real extenuating circumstances. More on those extenuating circumstances later. So what about calling 911, calling in the lawyers, calling in the big guns? This should happen whenever there has been any kind of breach of legislative compliance, when there's been any suspected fraud, theft, or major misconduct. You should definitely consult counsel in the event that you are the target of any kind of complaint or legal action. If in doubt, call your lawyer and get some comfort. So specialists and generalists, your general practitioner doctor, or that specialist to deal with a specific issue. Using a general practitioner who knows your business for simple issues is likely just fine. In straightforward matters, where a letter from a lawyer proposing an alternative amount of pay as a result of a termination would likely result in a quick resolution, so you might not need a specialist. However, there are circumstances in which you may want to engage someone who has greater level of expertise in the specific area with which you're dealing. Certainly, if you are dealing with unions, you definitely should have a labor lawyer who has specific expertise in this area. And in the unlikely and unfortunate circumstance that you find yourself going to court on a particular matter, you definitely need a litigator, someone who is experienced in the litigation process and one who specializes in employment matters. So now you've hired a lawyer. The lawyers are not inexpensive. That's because they are highly specialized, and when you need them, you need them. There are ways to get the best value from your relationship with your lawyer, however, and most of those ways are within your control. You need to always make very sure that you are clear on all of the facts of the case before you get on the phone with your lawyer. An HR professional or consultant, we tend to be a lot cheaper, but we give great value, can assist with this. Telling the story to a third party can tease out any details that will be really important to the lawyer in terms of framing your strategy. We know that departing employees in Ontario are generally entitled to more than the statutory entitlements set out by the Employment Standards Act. There are several factors that impact on the level of common law entitlement, so it's important that you have all of that info at hand. Generally, lawyers will want to know the position, so the job of the person who's being terminated, their length of service, their compensation level, including their base compensation and any other forms of compensation such as bonuses, commissions, car allowance, etc., and the age of the employee in question. You should also include any extenuating circumstances, such as whether there may be possible disability issues, including pregnancy, not that that's a disability, and whether you recruited the person away from otherwise secure employment. This, in fact, can be a factor that can call for larger amounts of common law payments. Taking advice. This is another way that you can make this process go more smoothly, and in fact, it may be the most important factor. I often see clients who are really mad at the situation they're in. In some cases, in many cases, they have put up with poor performance for a long time. That's another webinar, by the way, performance management, super important one. Stay tuned. And now those employers are facing demands from an employee who they perceive has already taken up way too much time and way too much money. Notwithstanding all of this, it will make very little difference as to how an employee termination situation turns out. What is set out under the Employment Standards Act is black and white. And unless you have a very documented case for cause, that's a very high standard, you will need to pay what is set out in that act. Common law entitlements, however, are not black and white, although they are informed by the factors we discussed before, age, position, etc., as well as a body of case law that influence what a lawyer and a judge might say is reasonable. For a beleaguered employer, it'll all likely sound like too much money. You always have the option to utter the always dramatic, "I'll see you in court," but going to court can be a harrowing experience and very draining on financial and management resources. It's often better to cut a reasonable deal and to learn from the experience by minimizing your chances of having a repeat performance. Ways that you can do this include setting out termination entitlements in offer letters and managing performance carefully to make sure that you don't get up angry and saying things like, "I've put up with him for so long and now this." So on that maybe not such a happy note, let's go to some questions and answers.
Hi, everyone. It's nice to be here with you on this somewhat rainy day here in Toronto. There's a couple of questions that have come in. I thought I'd start, though, with conveying to you a conversation that I actually had with a very good lawyer friend of mine a couple of days ago in anticipation of this webinar. And so basically I said to my friend, what is it that you would like to convey? So what's a good client and what's a challenging client for you? And she actually provided, I guess, much of the same information that we've chatted about already, about making sure that you are prepared. Don't leave stuff out of the facts of the case or the situation. To add color, but to remember that color is just that color. If you've fallen afoul of employment standards, for example, the fact that the ex-employee is just a nasty piece of work makes little difference. The other point that she made, and I think it's a fantastic point, is to make sure that you don't play lawyer. And it's easy for all of us, particularly those of us who have been working in the HR world for a long time, to think that we kind of have a pretty good sense as to what the right advice is. And we might, but the law evolves and it's very nuanced. And so what might have been the sort of right legal solution to a situation a few years ago may not be now. And it's not up to any of us to read all that case law and keep up on stuff. And so it's important to make sure that you acknowledge that lawyers are out there to be experts in this area in the same way that you are an expert at running your business. One more point before I go to one of the questions, and I love this question, is buying a new business. If you are in the process of buying a business, very important, crucially important, to have a lawyer involved if you are assuming existing employees with the new business. There's a lot that you need to know about the assumption of employee obligations, and certainly I've been dealing with a situation that involves a long-term employee with long-term status or service with the previous business employer, and that service, which we now know really governs what kind of severance somebody might be entitled to, is now a big factor in play with the current employer. And the current employer has only worked with this person for a fairly short period of time, but they are having to take into account previous service in terms of their go-forward plans, and that may have been avoided had there been counsel involved at the time. So here's I just have one question right now, and it's a great question. How much can you expect to pay for an employment lawyer? Well, I love that expression that people use sometimes, how long is a piece of string? I think as it relates to cost, there are a number of things that you can do so that you at least have a good sense as to what this might cost. You can and should ask the lawyer what their hourly rate is, whether or not all of the work on your matter will be done by the initial person that you come in contact with, who is most likely to be a more senior person in the firm, whether or not any of the work can be done by more junior individuals, which would prompt a lower hourly rate potentially, if that makes sense. And you also should ask and make sure that you understand about other cost disbursements, et cetera. But how much you can expect to pay, it is quite reasonable for an employment lawyer to say, look, based on the facts of the case, in order to write a couple of letters and try to get this resolved, you could be looking at X dollars. If you're further down the road and you end up having to go into litigation, it would obviously cost X times some exponential number. But it is fair to say that it would be very difficult for even the most experienced lawyer to give you an ironclad estimation of what a particular case or file will cost. And that's because no matter how much great planning you might have going into a situation, no matter how much you make sure that all of your data is done and all your ducks in a row, that we are dealing with people here on the other side. And as we know, people can be inherently unpredictable, and you never know what might come up. And so my suggestion would be if you have retained counsel on a particular matter, that you should actually either get progress billings or you should ask for regular touch points as to how much time has been spent. Because some of your strategic decisions may be informed on the basis of what's the risk reward here. What's the investment in terms of time that I'm going to have to make in order to potentially get to, to the result that I want to. It kind of goes to the idea of sort of reacting with emotional or without emotion to some of these things. Sometimes it costs you more in terms of lawyer time and your own time and your own investment of resources to prove a point than it is to simply agree to disagree and grit your teeth a little bit and make a payment on a release basis to an employee rather than making it a fight to the death, which obviously doesn't often serve anyone well. I guess I will make another concluding remark and just see if there's any more questions coming in. I have to say that with what I do, I often will deal with existing employment lawyers or lawyers who are have been retained by my clients, and I've met many of them. I also have a couple of counsel that I will refer to clients who, if they need them. And the way that I decide who I think is a great employment lawyer is really the following. I'm looking for practical advice. I'm looking for a lawyer who really wants to understand what the business is all about, what the risks of the business are all about. And I'm really looking for somebody who wants to work in partnership with the client, with me and the client, but who's also not afraid to convey the information that needs to be conveyed, i.e. to me or to a client, look, you're going down a bad road here. I know you feel aggrieved. This is not going to get you anywhere. Here's how we think that we should resolve it. So I think that a great lawyer in any area is worth their weight in gold, but particularly as it relates to dealing with employee matters. Obviously, having employee matters not go smoothly can present considerable risk and upheaval to a business, both on a day-to-day operational basis, on a cost basis, on a legal basis, and on a public relations basis. And with social media being the way it is now, a disgruntled employee can do a lot to tarnish your business reputation. So working closely on situations and making sure that you do your best to make sure that doesn't happen is I think, a terrific investment. So I'd be delighted, as always, at any time to chat with any of you by email or by phone. You have my contact information. I hope that you never, ever have to deal with an employment lawyer, but that if you do, that some of these tidbits have been in some way helpful to you. I hope to speak with you all again soon, and I wish you a pleasant rest of the day.